Welcome to today's issue of AJIL Explainers, in which members of the Board of Editors of the American Journal of International Law talk to us about changes in the second Trump administration. We are excited to welcome Professor Jaya Ramji Nangalis, a professor of law at Temple University, to talk to us today about the very important issue of immigration and migration. She has also written an essay in the latest issue of the American Journal of International Law, and we have added a link to that in the chat. So look for the all of the essays in the recent issue. And Jaya, with that, talk to us about immigration and nationality and migration in Trump 2.0.
So thanks so much, Ingrid, and huge thanks to you and Monica for both for organizing the issue that enabled the editors to talk a little bit about what's happening in our areas of expertise and for organizing this webinar. I should start by saying there's really been, as anyone who's been watching the news has seen, a blizzard of immigration changes since January 20th. And when I started writing my essay, I quickly realized it would be impossible to walk through all of them. So I chose to focus on three examples that represent violations of the non-refoulement principle from the 1951 Refugee Convention and the Convention Against Torture. And what I want to say in terms of the big picture, the concern that I present in the essay is what we're seeing is a shift in terms of disrespect for the rule of law under the second Trump administration. So rather than, and I should walk that back by saying the executive has long had broad discretionary powers in immigration law. Congress obviously sets the statute, but provides a lot of wiggle room for any executive to govern and regulate the immigration system. And we saw this under President Biden. He made many changes to the immigration system through executive orders, regulations, administrative efforts, in part because we just haven't seen a change to the federal immigration statute, a real change since 1996. So the statute itself is outdated. Congress has a lot of power over immigration, but provides these bare bones statutes that the executive operates under, and then the courts are deferential both to Congress and to the executive. So that's not new. That the executive is operating in has a lot of wiggle room, has a lot of power to operate within the immigration realm. I do think it's problematic, and it's a symptom of the fact that we haven't seen comprehensive immigration reform, that there's no political will to fix the system through Congress. But that's where our system is right now. The difference we're really seeing here with the second Trump administration, that we saw also with the first Trump administration, but I think it's become more extreme under this administration, is rather than operating by working with the lawyers, understanding the legal constraints, and conforming immigration policies and practices to those constraints. So coming in saying, here's what we want to do, and then talking to the lawyers, and the lawyers saying, okay, here's what you can do within the bounds of the law. The Trump administration has really been acting in clear violation of foundational, constitutional, and statutory standards. And these three examples that I discussed in the essay provide illuminate my point a little bit further. So the first development that I talk about is the closure of the border, which is a violation of both international law and the federal immigration statute, right? The principle of non-refoulement says that we cannot turn back people at our borders who have a well-founded fear of persecution in their home countries or who have a fear of torture. And our federal immigration statute says that any arriving non-citizen, whether or not they show up at a port of entry, and irrespective of their status, may apply for asylum. And so that question was actually litigated under the first Trump administration, and I discuss this in the essay, when that administration attempted actually a less draconian border closure, and the federal court said you can't do this because this clearly violates the text of the statute very obviously. But nonetheless, on January 20th, President Trump issued 2 executive actions closing the border, and now there's a lawsuit in progress, right? And so what happens? This is the pattern: is this all gets worked out in the courts? So the Trump administration issues these executive orders saying it's closing the border. This is in violation of the statute, and so then there's litigation over it, and that litigation is currently enabling. Well, at least until last week, was enabling individuals within the country to seek 2 lesser forms of protection to asylum: withholding of removal and convention against torture relief, which both prevent them from being removed but don't have the protections of asylum in terms of a path to permanent residence, enabling a family to obtain derivative status and come to the U.S. So that's the first example, this border closure example. This administration knows that violates the federal statute, but they proceed nonetheless. The second example that I talk about in the essay is the expansion of expedited removal. So we see the closure of the border externally, and then we see bringing the border into the interior. So expedited removal is basically a process, a deportation process without a hearing before an immigration judge, and people who are placed into expedited removal are detained throughout the proceedings. And if they express a fear of return, then they are and then they can avail themselves of an interview with an asylum officer to figure out whether they have a significant possibility of a viable protection claim, a claim to non-refoulement. Since 2004, this expedited removal was put into place in the 1996 immigration law. It was effective April 1st, 1997. Since 2004, expedited removal has applied to people who enter without inspection and are apprehended within 100 miles of the land border within 14 days of entry, as well as sea entrance. But the main focus is on land borders. What the Trump administration has done is now expanded expedited removal to the full extent of its statutory authority. So Congress, this is permitted under the statute, but prior administrations have not done this because they were worried about the constitutional constraints. So what's happening now is that any non-citizen without lawful status apprehended anywhere in the interior of the U.S. who can't prove that they've been in the U.S. for more than 2 years can be immediately deported without seeing a judge. And this is being used in bad faith. So that's one of the other things we're seeing is really these bad faith actions by the Trump administration. It's being used to make arrests at courthouses of people who are showing up to their immigration court hearing as they believe they should. They're doing their best to follow the law, and this is being used to make courthouse arrests. And I'm happy to talk about that in a little bit more detail, but in the interest of moving on, just to say that this was found, the district court in the District of Columbia found in late August that this violates fundamental procedural due process protections. Running a Matthews v. Eldridge test, they said there are just insufficient procedural protections here to make a determination about whether someone has been actually in the U.S. for 2 years to enable them to contest their removal. So that's the second example, is kind of where other administrations, Republican and Democratic alike, have feared to tread. They've, other administrations have presumably talked to the lawyers, and lawyers have said, expanding this nationwide, that there are real constitutional risks there, but the Trump administration has proceeded nonetheless. And then the third example is the one that maybe the audience is most familiar with, which is rendition to torture. So this has been in the news a lot. There was actually a very good article in this week's New Yorker by Sarah Stillman, who's on the immigration beat and always produces excellent work about what's happening and kind of post what happened when I additions to what had been happening when this CPUS piece went to press. So here, the Trump administration is using a practice that we saw previously under the first Trump administration, um, that dusting off a very old statute that hasn't been used in many years and using it in ways that are kind of questionable in terms of the relationship of what they're trying to do with the text of the statute. So we saw this with the statute that was used to close the borders during the COVID-19 pandemic. And we see now the administration dusting off the Alien Enemies Act from 1798, which, to tell you right how ancient that is, this was passed with an eye to being at war with France and worried about French nationals. So this was a very long time ago. It's only been used 3 times since then, most notably and notoriously for Japanese internment. But even in that case, there was a civilian review board hearing to contest that people could use to contest their classification as an alien enemies, which we're not seeing now. So what does the Alien Enemies Act do? It enables the government to apprehend, detain, and remove non-citizens from hostile nations where there's a declared war, which we don't have here, or a threatened, attempted, or successful invasion or predatory incursion. So in March, President Trump invoked this act against Tren de Aragua, which is a transnational criminal organization based in Venezuela. Pretty clearly not a foreign government, pretty clearly no declared war, but the administration claimed that there were hostile actions and irregular warfare, which would then enable them to remove Venezuelans 14 and older who are members of Tren de Aragua and not permanent residents. So the next day, in direct violation of a court order from a federal judge in DC, the administration deported 238 Venezuelans and 23 Salvadorans who were accused of being members of a different gang, MS-13, and they were sent to El Salvador, where they were placed in CICAD, a high security prison known for human rights violations. So it's really hard to imagine a clearer violation of non-refoulement, given what was known about the conditions in CICAD. And so many people, I think, will be familiar with the saga of Kilmar Armando Abrego Garcia, who was granted withholding of removal in 2019, granted an order that he should not be returned to El Salvador, and he was sent to CICAD. There was a preliminary injunction. Federal district judge issued a preliminary injunction ordering his return. That was affirmed by the Supreme Court. And in response, the White House posted on social media, he's not coming back. So really clear defiance of the rule of law in this situation. And to make a long story tragically short, Mr. Abrego Garcia was tortured in CICAD. There are a lot of reports, a lot of good journalism coming out right now about what happened to all of these people in CICAD, and they were tortured. We also saw over Labor Day weekend an attempt to remove a few hundred unaccompanied Guatemalan children. In that case, a temporary restraining order was issued by a federal court to prevent the removal before it happened. And so then finally, I'll just sorry, almost done. I know I'm going on for a long time. I'm almost done. The last point I wanted to talk about is just this practice of third country rendition, which is what Sarah Stillman's article in the New Yorker is about. And this is really a concerning violation of due process because there's no notice of where these non-citizens are being removed to and no opportunity for individual assessment or review. So normally what should happen, an immigrant should have a notice to appear. They should be designated for removal to a given country. And that person can then say, no, I don't want to be removed to that country. I have a fear of torture there. Or yes, I can be removed to that country. That's not what's happening here. People are simply being removed without any information, sometimes until they're on the plane, sometimes after they get off the plane, of where they're going to go. So this was preliminary enjoined. That injunction was stayed by the Supreme Court in June. And so we're seeing now migrants being shipped off to a variety of countries they've never been to. And these countries are being paid millions of dollars by the Trump administration to accept these deportees. All right, so I will stop there. Sorry for going on so long, but I'm looking forward to your questions.
Yeah, no, it's an excellent intro. And before we get into some broader questions, I just want to try to put a little bit finer point on the the issues you have with the Trump administration. Let's imagine that I believe that we've allowed too much immigration into this country. We've allowed too much illegal immigration into this country. I think we should close the border. I think that people who are here illegally should be removed. And I'm happy to see people that are associated with terrorist organizations removed quickly and promptly from American soil. Understanding your answers or your objections, for example, the closure of the border, your objection there is just with respect to people who have a well-founded claim of persecution, right? So it just goes to the refoulement, and otherwise a closure of the border is perfectly legal. That's my first question. And the second is, could you just put a little bit finer, a very short explanation of the international legal instruments that are at play here, right? So you've referenced international legal obligations. Like, where do those come from? And to some extent, why is the president bound by them in your view?
Yeah, great, great. Thanks so much. With respect to the border closure, um, so that's right that the main concern from an international law perspective is enabling people to apply for international protection. And so that international protection comes from mainly from two treaties. First of all, the Refugee Convention, which tells us that people with a well-founded fear of persecution on the basis of one of five grounds can't be returned non-refoulement. We cannot return them to their country of origin or send them somewhere where they'd be at risk of return to their country of origin. And then the Convention Against Torture, which says people who have a fear of torture similarly cannot be sent back. Those are of course, we operate in a country with a non-self-execution rule. Those have been incorporated into domestic law through statutes. And so the Refugee Convention, the non-refoulement protection, is now part of the Immigration and Nationality Act, and FARA brought in also the Convention Against Torture. So the president is constrained domestically by these federal statutes. The international legal concern, looking at it from a U.S. perspective, that is really more the Congress could change that. Right? The last in time rule, they could change that. And certainly there has been some talk of withdrawing by this administration, withdrawing from the Refugee Convention. I think that the concern there is really more about the message that would send to other countries, and the right, not up, but there would have to be some withdrawal from the treaty. But in terms of what is actually constraining the president, I would say it's the federal statutes.
What about these situations where President Trump announces some kind of hostility to people from particular countries, right? So deciding that we're no longer going to accept people from Afghanistan, and we're going to go back and review all of folks who are in the country who came from Afghanistan, or deciding that we, quote unquote, in a really ugly way, saying, quote unquote, we don't want people from Somalia here. Is this within the president's power to make these kind of off the cuff, like, I don't like people from this country today, and block their entry into the United States?
Yeah, so I mean, I think that's going to be subject to litigation, right? Because there is a part of Section 212F of the Immigration and Nationality Act, does and gives the president here quite broad powers, right? If he thinks there is a threat, but there are still he still has to make the case. There are still non-discrimination laws that are going to apply, and that was what was at issue in the Trump versus Hawaii case under the first Trump administration. So there are some real legal constraints there, and I think look, certainly you know, what he said is deeply problematic, and the optics are not good. So that is would have to be parsed out in court, I think, to determine where he sits between his quite broad authority to restrict the entry of people if he thinks there's a threat, and non-discrimination obligations. And there's a difference between his power to control entry and what he can do with people who are already here in the US.
Thank you, Jaya. That's all, and Ingrid, for that like comprehensive overview of the landscape. So I guess I want to, if it's okay, go back to your starting concern, which is your concern that there's just a manifest disrespect for the rule of law here. Sometimes just blatant disregard for court orders, sometimes obvious pushing of the boundaries where other executive branch lawyers were unwilling to go, sometimes violations of statutory provisions, and sometimes multiple ones of those at the same time. And I have to say, as an observer who's sort of watching this at a few steps more removed than you are, it seems to me that the violation of the rule of law is sort of part of the point. That part of the point of this exercise is to break the old system and to sow some degree of chaos and confusion and fear among those who might otherwise come here, so as to send a message that we in America are doing things differently now. So I guess my first question is like, does that strike you as correct? And then the second question, and how would you think about that? And the second question is, nevertheless, like there are other players in our constitutional system who are entering the fray and in various ways trying to shape or resist or push back on what the executive branch is doing. And so these efforts to sort of take it outside the law and end up finding their way back into the law in various ways. And so my question, the second question then is, how do you see that process unfolding? So do you see these efforts at resistance and pushback and reinterpretation by the courts and whatnot as indicative of a like an inability of the executive branch actually to go completely outside the law and send completely the kind of message that it might send if not for these efforts to bring it back into the fold.
Yeah, those are both great questions. I think I agree with you on the first point. I think the cruelty is the point, and that's also a big change from what we've seen in the past in Republican and Democratic administrations. There's really um, a both a deterrence effort to try to stop people from coming here, and then a part that's pretty deeply concerning, right? This ethno-nationalist kind of leaning towards ethnic cleansing, right? We're going to get rid of all of, right? First, we're going to get rid of people who are undocumented, then we're going to get rid of I mean, what we've really seen that's unprecedented is the attacks on permanent residents, right? Who are always considered as having a similar level of rights to citizens. And now we're seeing under this administration, those rights really being pulled apart. So that is pretty concerning. There is certainly case law out there that says the immigration law can't be used as a deterrent, right? That's not the idea. I don't know. I'm actually not sure if anyone has that was litigated under the Obama administration. I don't know if anyone has pulled that out now. The litigators are quite busy doing other things, which takes me to your second point. And I actually wrote a chapter about this that just came out, I think, earlier this year, about using the courts as a place to make policy, which I don't think is a good idea. Basically, the short answer is this where we are right now is a consequence of Congress's inability to act, right? What we need to see is immigration reform through legislation. And there just hasn't been the political will for 30 years now to see any kind of immigration reform that's going to make changes that would enable people to come here lawfully to work, to fill labor market needs, right? There are many changes that need to be made. So I think you're right. We are seeing a lot of contestation in the courts on every single one of these measures. I only touched on three. There are many others, and we're seeing contestation in the courts. We're seeing certainly federal district courts saying in many cases telling the Trump administration that it cannot do what it's doing, that it's constrained by statute, that it's constrained by the Constitution. And we're seeing those cases often go the circuit courts upholding preliminary injunctions. What we're seeing, I think, really concerningly for the rule of law in immigration is the shadow docket in the Supreme Court doing more work than it should be. And so one example that I'll talk about, and I should say that I submitted an amicus brief in this litigation, so I'm not completely without a stake in this, but I will try to remain unbiased. The real concern is, in that litigation, there was litigation over the termination of temporary protected status for people from Venezuela. It's 600,000 people here under that status, and the district court issued a preliminary injunction. The government requested a stay. It went up to the Supreme Court. The Supreme Court issued a stay of the preliminary injunction, which was fairly concerning because it's about 600,000 people losing status, and it's not clear how the government, right? If you think about the standards, it's not clear how the government was being harmed by extending the status for some time. Then it went back down to the district court. The district court issued a grant of summary judgment in favor of the plaintiffs and refused to stay, and said this is going into operation right now, and we're retaining the TPS status for the Venezuelans. That went all the way back up to the Supreme Court, and in a one paragraph opinion, they said this is generally in the same posture as it was last time it came here, and we are going to issue the government a stay. And so that was pretty concerning, because summary judgment isn't not the same posture as a preliminary injunction. And I fear for the legitimacy of the Supreme Court, because it's issuing these it's using the shadow docket, these very terse one paragraph opinions. No one kind of understands what's going on. And it's not great for the rule of law.
I have a question that shifts gears a little bit and looks more at the international, but Monica, did you want to follow up?
Another question about the domestic, if that's okay,
Yep.
before we international, which is just to your point about policymaking through the courts, and then not just policymaking through the courts, but the sort of, I take you to be saying, would this be an accurate take on what you just said, that the sort of rule of law problems that infect executive action, also because of the way in which the frequency and the rapidity in which it's happening, is also causing a deficiency in the rule of law of the court's jurisprudence, because it's not acting transparently, it's not giving reasons, it's using the shadow, it's doing all sorts of things that are sort of inconsistent with the judicial function. And so you're getting sort of like an infection of one branch as a result of the conduct of another. So I guess that's sort of what I'm hearing, and I want to hear if that's how you would phrase it. But
sorry,
yeah.
go ahead. Yeah.
Okay, and then let's talk about Congress for just a second, which is, so you say what we actually need is legislative reform that actually fix our immigration system, which sounds right. Seems like it's been a long-standing problem. I think you said since the 1990s, right? Congress has not actually legislated in this area. Do you see, it seems to me that Congress is super acquiescent. Do you see any prospect for instigating congressional action by virtue of all demonstrable efforts to deal with immigration in ways that are not palatable to large segments of the population and not responsive to the basic dynamic of migration? If you wanted to take Ingrid's initial phrasing, a lack of adequate regulation on the basic dynamic of immigration into this country.
Yeah, it's a great question. I'm just going to turn briefly to the first question. I think that's right. That's what I'm saying. But also, there's just really this dizzying instability when the law is coming from the executive branch because right, and we saw this real whiplash both under the first Trump administration and the Biden administration, where the executive orders something, it gets enjoined, and just understanding what the law is on any given day is an exercise, and that is not good for anyone. So that's also part of it, right? The law should be at least somewhat stable, and there's this real dizzying instability. Yeah, and it's a great question about comprehensive immigration reform. I think it's just a real symptom of congressional dysfunction, of dysfunction in our politics. So, where we are now, I think there is so much that could be done through good legislation. We could think about having an immigration system that actually regulates immigration, and I think that's the challenge that both sides see, is that what we have now is not regulating immigration. There are lots of jobs here. There aren't lawful ways to get here to get those jobs, right? There are people with protection needs. We're not finding ways to meet those needs, and so there I have many ideas about how this system could be reformed in a way that would be beneficial to the migrants themselves and to the U.S. But I am not sanguine about the possibility of reform. I think Congress can't even talk to each other, and one of the things that I highlight in the piece, and that we see from this administration that's really concerning, is kind of a reality TV approach to governing, where whoever can say the most outrageous thing is the person who captures the news media, without a real commitment to sitting down and working through the nuts and bolts, again, that we've seen in prior administrations, Republican and Democratic alike. I might not have liked what the Bush administration did on immigration, but it was thoughtful, right? There was an effort to get to the nuts and bolts, and whether or not you disagree with them, it was an effort to put together real policies that might work, rather than to kind of appeal to the lowest common denominator through whatever kind of outrageous thing you can say.
Moving to the kind of global stage, I'm trying to piece through, what is the global impact here going to be? We have a lot of, violations of US statutes. We have a lot of like the court saying one thing and the administration not quite doing that thing. Um, I guess, and when we think, how will that play globally? I mean, I think one thing, if I recall the headlines right, we are one kind of global impact is we are seeing more and more countries, I think, become more restrictive in their immigration policy, whether that's a result of what's happening in the United States, or whether we just have broader global populist movements that are all kind of linked together. But certainly, as the United States pulls up the drawbridge, that may have an impact on other countries and their immigration policy. So that's one. And I guess this kind of executive power, acting quickly and so on, maybe other countries will follow our lead, but that seems very constrained by the domestic situation in each other country. And it's a little bit interesting that international law regulates so little here in a way. And that would be another question to you, whether you share that sense, right? That so international law says you can't return someone to a place where they will be persecuted under one of a set of listed grounds, and you can't send someone somewhere where they will be tortured. That leaves, and you need to give people probably some due process rights as a matter of human rights before doing something that affects their liberty. But that leaves just the entire universe of effectively like an incredibly broad universe of decisions about who goes where that is not regulated by international law. So I'm curious if you share that view. And then also, if that's true, is there really going to be any impact from what's happening in the United States on, international law as actual international law versus a set of norms and practices?
Yeah, those are both great questions. And as you say, the non-refoulement principle, right, that it has been under pressure globally for some time. Really over a decade at this point, and we're seeing in the UK similar development as we're seeing in the US. I mean, the UK actually kind of was the first mover on this third country rendition we're seeing that, probably a little bit more above board, but they initially had the agreement with Rwanda where they were going to send asylum seekers there, which didn't work out for them. And so I think we're certainly going to see. I think part of it is these populist groups that are in conversation with each other, that are funded by U.S. groups, that are pushing internationally. And I think there's going to be kind of an echo chamber effect where they feed off each other. And I think we're going to see more and more of this. And also as the US, right, as the main hegemon in the world, is not only not complying with um, these international legal obligations, but not really worried about whether anyone else is. I think we're going to see lots of different countries just defying international law because, or specifically non-refoulement and human rights law, because they can. And one kind of very clear example of that is, of course, Trump's enabling of President Bukele in El Salvador, right? Who's someone who is, you know, acted in violation of many basic principles of human rights law, and has been criticized by the US, but who is now a buddy of the US, and who is empowered to continue running his prison, where he pulls people off the streets, throws them in there, and accuses them of being gang members without any due process, and then he's able to do what he wants with them, including torture. So I think that's going to be problematic. Broader human right, both the ramifications for non-refoulement and the broader human rights ramifications, I think, are going to be problematic. I think you're absolutely right that international, right, I've written before, right, it's kind of astonishing how little international law regulates the movement of most people, right? It regulates the movement of the hypermobile, like you and me. It enables us to move safely, speedily, with ease. And it provides some protections for people seeking refugee and Convention Against Torture status. But in terms of most humans on the move, it regulates them very little. And in some ways, it's a parallel story from the domestic sphere, right? We can imagine a different scenario in which international law actually regulated movement. I like to say, like, you can imagine this being a very boring job that some functionary in Geneva like uses a computer program to figure out which country has labor market needs, which country has people who have skills or interests in moving. People could move from one country to another. We see this happen with refugee resettlement. People could move lawfully from one country to another, right? There's a whole world of possibilities, but instead what we have, of course, international law drafted by sovereigns, and right, this protection, this ability to control the borders is viewed as a core function of sovereignty. So there's just very little regulation, which is not good for migrants, and it's not good for states. But again, we need the political will to create something different, and that we've not actually ever seen that in the international sphere. What we do have, and the difference, I will say, between the impact this is going to have in some regions of the world, we do have in Europe, in Africa, in Latin America, we do have regional bodies that are going to uphold the rule of law in terms of refugee protection and human rights. So those countries are going to be more constrained in what they're able to do because they will hit the African court, the European court, the Inter-American court. And that's very different, right? In the US, we operate without those constraints. So when I go to those countries and have conversations with lawyers working in those countries, it looks very different because there is this supranational body of law that is going to be applied that people are going to take seriously. But still, in terms of an overarching, if we think of international law's function as coordination, even, right? We
But
don't see that with
and
migration.
I know Monica wants to get in, but even those human rights obligations, those still really don't go to who gets to move where, right? This is to your point outside of the two contexts in which we've already described. Yes, in Europe and the country subject to the Inter-American Court, you're going to have perhaps greater protections before you're removed and so on. I'll let Monica get in, but I do think, the fact that we haven't been able to solve this domestically is, of course, a function of our like lame, dysfunctional Congress. But it's also just true that these problems are hard, right? And I think that's, why there is no global system that you've described. I mean, they're hard because people cling to these ethno-national ideas and basic ideas of identity. And I think in some ways pretending that there's like an easy fix at the border if Congress would just do it does kind of a disservice to the nature of the problem. It's actually hard to figure out who should be here and why. Well, I won't. I think that
Yeah.
not always hard, but sometimes hard. Monica, I know you wanted to get in.
So I'll push back on that a little bit. I think it's hard culturally and politically. I think there are solutions, right? There are kind of technocratic solutions, but I think the challenge is not legal. The challenge is not technical. I think the challenge is, right, there are real cultural and political challenges, and those are tied, right? The cultural challenges win elections. And so I think it's not going to be easy. Right. There are many ways you could think about changing things, but actually making the changes, I think it's very, very difficult. Sorry, go ahead, Monica.
No, it's actually a great segue to the question I was going to ask, which is, this does seem like a long-standing problem on the one hand, and on the other hand, it also seems the case that in the past 10 years, it has galvanized populations in ways that it previously had not. And I'm just wondering to what you attribute, because the international law has stayed the same, largely, right? We haven't seen massive shifts in the international legal architecture like the domestic one. And nevertheless, like there have been like huge, it seems to me, social and political and just like movement shifts, right? Economic shifts. And so I'm wondering if you could explain a little bit why this issue has become so salient, and why now we're seeing, I think, what can reasonably be called a backlash in many societies that otherwise view themselves as liberal and progressive and willing to have like a sort of cosmopolitan urban centers. Why you're beginning to see this like dramatic backlash in response to what seems like an uptick in migratory patterns.
Yeah, it's such a great question. We could spend a whole 45 minutes more on it, so I'll try to be as brief as I can. I mean, I'll start by saying we're not actually seeing, migrants have always been around 3% of the world's population, and I think it's now maybe up to 4%, but we're not seeing a huge percentage change. What we are seeing, you're right, the laws haven't changed. The international law has become increasingly outdated and kind of not meeting the needs. So I think that's part of the problem. I think part of what we're seeing is technological change, which enables movement in ways that we didn't see before, right? The advent of the smartphone, right? We've seen a lot of changes there. So that has enabled movement. We've seen the political dimension, where I think we've seen leaders seeing that they can win elections by kind of pointing to this idea of border invasion. I think is very effective. It has been very effective in Europe, in the US, in Australia and winning elections, because I think you can play on these cultural fears that we were talking about before. So I think there's all, and I think that is particularly effective currently, where we're seeing these kind of major economic transformations as we move into a digital economy, right? It's a time of transformation, and I think that impacts perceptions. And I think, the what we're seeing, and this relates to the question Ingrid was asking earlier, um, international law is not regulating the way that people move. And so we've seen in the past 15 or 20 years the rise of carrier sanctions and other means that prevent people from getting on a plane, and visas, and then that's been longer standing, prevent people from getting on planes and moving from one country to another. So what we see is a whole bunch of people showing up at a border, and that's a very fruitful political optic for politicians who want to take advantage of it. So part of the problem is that we don't have the infrastructure, but then that just snowballs into a larger challenge. And yeah, there's a lot more that I could say. I'll try to rein myself in a little bit.
Well, then maybe we'll just end, unless Ingrid has follow-up questions with I have one more question, I should say, which is maybe you could tell us a little bit about where you see, like I asked you the question where you see like the US legal process going. Maybe we could end with a question about whether you see changes coming in the international legal process going forward. I know Ingrid asked like a version of this question earlier, but now that we have like the full landscape, if you had to predict like where will we be legally and politically at a more global level in the next like 10 years, what would you say?
And if I can just refine the question to ask you to add a little bit about maybe climate refugees in your answer to Monica, whether you see that as a place where there'll be a lot of change or not.
Yeah. We haven't even touched on climate migration. I am not sanguine about change at the international level. Where I think the future is going to be over at least the next 10 years is regional. I think there are really interesting things happening regionally. And I think we're going to see regional migration leading the way. And my hope is that happens in a way that's not kind of a containment strategy, but rather enabling people to move, what we've seen in South America with the Venezuelans, enabling people to move. That situation is not perfect, but it's a good example of people being able to move to countries where they speak the language, that are close to home, and then integrate and potentially return home if needed. I think similarly, with climate migration, I think those the international law does not have a lot to say about it. Those people are generally not going to fit within the protection sphere of non-refoulement, either under the Refugee Convention or the Convention Against Torture. Migration is mentioned very little in the international agreements, right? In any of the climate agreements. So I think we're going to see primarily movement regionally, and my hope is that then those regional efforts can lead the way to build an international law that's more responsive to what's happening on the ground. But that is pretty hard to imagine in the current political environment that we're. I mean, we saw what happened with the Global Compact, which was basically dead on arrival. And I think it's going to be some time before we see some kind of reform on a broader international level.
In closing, thank you a lot. This is really helpful, and I have always admired the space that you occupy between the really domestic and the sort of global. It's a really interesting place to work. I want to remind folks who are watching live that we will be recording a webinar with Jorge Contessa later today on the view from Latin America. So some overlap for sure with these themes. And for those who are not watching live, you can find the recording of his webinar and this one at the AJIL webpage. So thank you so much, Jaya, and we really appreciate all that you do for the journal.
Thanks so much to both of you for organizing this.